That takes us to the bottom of page 5, S 628 by the senator from Beaufort. Amendments on the desk. Senator from Beaufort, what purpose do you rise, sir?
Be heard on the amendment.
Let him publish the amendment. Publish the amendment.
Amendment number 1 is by Senator Davis, amends the bill by striking all off the enacting words and inserting.
Senator from Beaufort is recognized on his amendment.
I'll be brief. We alluded to this sometime earlier today. The underlying bill is the pharmacy bill that authorizes pharmacists to dispense contraceptives without the necessity of having a script from a physician. The bill was amended in the House to include the central fill pharmacy language. If you recall, we discussed central fill. The amendment that's currently on the desk right now is the substance of Senate Bill 150, the Compassionate Care Act, with the exception that the offending 6% sales tax in regard to the point of sale of cannabis products has been removed. The idea being that if this amendment were adopted and returned to the House, it will no longer be subject to that point of order and will be subject to an up or down concurrence vote in the House.
Senator from McCormick, what purpose do you rise, sir?
Point of order, Your Honor.
State your point.
Under Rule 24A, the amendment must be germane to the bill. It must be a natural, logical change or expansion directly related to the subject of the bill and must not raise any new or independent matter. The only subject matter of the current bill is allowing pharmacies to give out birth control pills in certain circumstances. Proposed amendment has nothing to do with the subject of this bill as it establishes the infrastructure for medical marijuana in our state. I note this provisions of the rule must be strictly construed. Therefore, I request that the amendment be ruled out of order under Rule 24A.
Mr. President.
Anyone else wish to speak to
Mr. President.
Senator from Beaufort, speak to the point of order.
Speak to the point of order. Appreciate the Senator from McCormick's point of order. What he neglects to mention is that the House amended this bill to include not only the pharmacy dispensing contraceptives, but also central fill, and further neglects to mention that the House amended the central fill component of this bill to make a specific reference to the dispensing of cannabis products. And I reference you to Section 40-43-195, subparagraph B, subparagraph 3 below B. I'm sorry, 4 below B, and then below that subsection D, they're talking about providing of dispensing medical cannabis products. The fact that the underlying bill was amended by the House to make a reference to medical cannabis products means that this amendment is not raising a new and independent matter. It's in this bill. It was amended by the House to make reference to medical cannabis. And I would argue, Mr. President, that it is a natural and logical expansion of that particular provision in the bill because we have to define what medical cannabis is. The House saw fit to put medical cannabis into the central fill bill. It did not define it. This is a natural and logical extension of that in that it defines it.
Others wish to speak to the point of order. Senator from McCormick.
I appreciate the senator's position. However, what's that got to do with family court? There's provisions in this bill dealing with family court.
Senator from Spartanburg, Senator Martin, speak to the point of order, please, sir.
To the point of order.
I clarified he needs to be speaking to the point of order.
I'm speaking to the point of order as it relates to must not raise any new or independent matter. And in this amendment, there are numerous new and independent matters. For instance, it talks about family court treatment of people who use marijuana or have a card. It talks about a host of different types of engagements for employer-employee rights. I mean, there's a host of new matters that have been raised that are not raised in this bill, in the original bill, even with the limited amount of change, the 1 or 2 sentences that have been changed in the original bill. Original bill was 11 pages. Now it's 12 pages. And it's only 11 and a half pages. So it only added just a few items. But the Compassionate Care Act deals with funding. It deals with a host of issues, card holders. It deals with 5 processing plants. It deals with 15 grow fields. It deals with on and on and on and on. I could spend the rest of the afternoon if the president would like for me to go through the bill and talk about all the new things that are not included in this bill. I can do that. They are so numerous it would take me an hour to go through them. There's almost one on each page of the 53-page original bill of the Compassionate Care Act.
Mr. President.
Senator from Beaufort, speaking further to the point of order.
Mr. President, it was the House that amended the pharmacy contraceptive bill with central fill. It was the House that put language in there regarding to the dispensing of medical cannabis products, defining under the terms upon which those medical cannabis products can be dispensed or authorized is a natural and logical extension of what the House put into this bill. Furthermore, I would say it does not raise any new or independent matter. It's the House that put a reference to medical cannabis in the central fill bill. It wasn't me. And so looking at this particular language that's before us and applying the 2 prongs of the Rule 24A test. One, is it a natural and logical change or expansion? And I would argue that defining what's meant by medical cannabis is logical. You can't just throw it out there and not define what it is. And second of all, the second prong is, doesn't raise any new or independent matter. It does not. The underlying bill as amended by the House included a reference to medical cannabis. Those are the 2 prongs of Rule 24A. The fact that I go into detail in S-150 in explaining what that logical extension is immaterial. The fact remains they are logical extensions.
Senator from Orangeburg, what purpose do you rise?
Speak to the point.
You're recognized to speak to the point.
The question is not how long it takes or how many pages it takes for the logical extension to take place. If something needs to be explained or extended from what came to us from the House, we're not limited to doing it in a paragraph or less, doing it in a sentence or more. And so when they make reference to medical cannabis, we have every right at that point in time to have an extended discussion about medical cannabis because it's a logical extension of the bill.
And I would argue, to your point, would be that it's our responsibility to be thorough.
Senator from Orangeburg has the floor. Excuse me, I'll come back to you, Senator Beaufort. Yeah.
Well, and I'll make that point. It is our responsibility. We can't just let undefined items come over to us and not define them. If it takes us more than 1 page to define it, that's not an issue. The question is whether this is a logical extension of the bill, and an undefined item in the bill being defined by us is logical.
Senator from Beaufort, do you want to speak further to the point?
No, sir, Mr. President.
Senator, anyone else wish to speak further to the point of order? Senator from McCormick.
I can go through and go page by page if necessary, but there are so many new items in this argument of newness. I mean, they're dealing with employer-employee rights. They're dealing with hospital rights. They're dealing with doctors' rights and patients' rights. I mean, this is so expansive that the rule has no meaning whatsoever if you were to allow all this new and independent matter to come before. It's not germane to the original pharmacy bill that was sent over. Just because they said one line about medical cannabis doesn't open the whole door for all of these new programs, regulations, and there's 77 references to criminal law here. I don't know anything in that said y'all could go, that this bill could go into criminal law. It's allowing people to violate the law. It certainly didn't say that in the pharmacy bill, that you could violate state law, and this bill does.
Thank you, Senator.
Mr. President.
Senator from Beaufort.
Every single one of those items that the Senator from McCormick references pertains to medical cannabis. And again, it doesn't matter how detailed or specific we get into defining how medical cannabis is going to be authorized and dispensed for use by medical patients. They all relate to medical cannabis. The House put medical cannabis in the central fill amendment. The House amended the pharmacy bill to include the central fill. The 2 prongs of 24A are met. It's a logical extension in that it defines what medical cannabis is, and it does not introduce any new or independent matter because the underlying bill as amended by the House includes a reference to medical cannabis.
The Senate will stand at ease. Senator from Beaufort.
Mr. President, I'm happy to, while you're taking this under advisement, to further explain, but I think that having debated this for 3 weeks, having gone through extensive debate, having put up several amendments that were painstakingly drafted and reviewed and argued and adopted or rejected, I think everybody in this chamber understands what is in this particular amendment. And I think, that speaks to the practicality of this germaneness rule. A lot of times, germaneness, I think the underlying reason for germaneness is you don't have something tacked on or lopped on or bobtailed at the last minute that the body has no idea what it is. This is the absolute, opposite of that. Everybody knows what this is. I wasn't the one that amended this bill in the House to include a reference to medical cannabis. I wasn't the one who sent it back over here to us in that posture, but that's what's presented before us here. And there's every reason, if the House saw fit to make a reference to medical cannabis in the central fill bill, which it attached to this underlying bill, I think it's incumbent upon us and a natural and logical extension to define what medical cannabis is, and it certainly does not raise any independent matter. Mr. President.
Senator from Beaufort.
May I further speak to the point?
You can further speak to the point.
In addition to the reference to medical cannabis in the underlying bill to which the amendment attaches, there are numerous other areas in which there is complementary provisions of what was originally in S-150 and which would now be added to S-628. Both create a new kind of pharmacy licensed by the Board of Pharmacy. Both require pharmacists to perform duties regulated by DHEC. Both require pharmacies to register with DHEC, require regulations to be published by the Board of Pharmacy, require the Board of Medical Examiners to develop training and continuation for the pharmacists, require specific drug label information, patient confidentiality requirements, procedures for returning of dispensed products. This is not an unrelated bill. This bill deals with what can pharmacists do in the ordinary course of their profession right now, and it is a natural logical extension for those reasons as well. I just point out the medical cannabis reference because that's the most obvious example of why the rule has been satisfied here, but there are many other areas in which the 150 original, now the amendment, relates to the underlying central fill and pharmacist language of the bill.
Thank you, Senator.
Two.
Senator from McCormick.
Thank you, Mr. President. This new bill even goes into gun rights as to whether or not somebody can own and possess one of these certificates and whether or not somebody can own a gun. I certainly didn't see anything of that, any kind of limitation like that from the House.
Okay. Speak to the point. Further speak to the point.
What the senator is referring to is a 1986 federal law which states that if you have a gun permit that you cannot also possess a Schedule I substance. The underlying bill requires there to be a disclosure to all medical cannabis patients of that 1986 federal gun law. It's perfectly reasonable in talking about medical cannabis products and trying to make a natural and logical extension to define those instances where individuals might not be able to avail themselves of those medical products, and that's why there's a reference to the 1986 federal gun law, which was in the bill passed in the Senate.
Senate will stand at ease. The Senate will please come to order. Prepared to rule on the point. The point of order is sustained. Senator from Orangeburg.
Appeal the ruling of the chair.
I understand.
Okay, under Rule 7, the matter is under debate for 30 minutes. Each side, the pros have 15 minutes, the cons have 15 minutes. You have to, when you go to the podium, you need to designate whether you're speaking for or against the motion or the appeal. Then at that time, we will then vote. Senator from Orangeburg.
Be recognized.
Senator from Orangeburg is recognized.
Members, I'm going to speak briefly for the appeal, and then I'm going to ask to withdraw the appeal. But I think we have got to recognize that under the way, and with all due respect to the president, he can only rule on the rules we've got. But the rules we got are hamstringing us in our relationships with the House. And the only way this is going to change is when we get around to rules next time, which will, I guess, meet in January possibly, we got to consider where we stand on this. Clearly, there's time after time after time where we are talking about an amendment that is clearly related to the bill. We've gotten so hyper-technical now that if it's not in the same exact code section and semi-code section, we can't do anything. Yet we are sitting here watching them send us tons and tons of unrelated stuff, all right, totally unrelated things. We have to bring some parity, equity between the way the bodies are operating. And if we're going to, if they're not going to enforce their rules, and we're going to over-enforce our rules, it puts us at an unfair disadvantage. So I'm just asking you all to remember this, because the way, for those of you who are relatively new, don't know, or maybe you do, most of the time the rules get discussed in October and November before we come back in January. We don't meet and discuss them, but you will be called about potential rules changes. And I want you to think about this moment when we talk about the rules for germaneness when we go forward in the Senate next year. And Mr. President, with that, I ask unanimous consent.
Senator from Sumter, for what purpose you rise?
Ask Senator Yield for a question.
Yes.
Senator Yields. Senator Yields.
Senator Martinsburg, some things are more about the institution than they are the subject matter of the bill, isn't that right?
Absolutely.
And I just, for the benefit of the body, I want to ask you, do you recall a time, well, it's been multiple times in the last few years, when the Senate might take a very strong position on a bill, right? And we get to the end of session, second year, things are going to die if it doesn't pass, and we get a bunch of House bills, and in the past, we have amended House bills with Senate bills that we took a strong position on to get to conference, right? Because they wouldn't take those bills up.
Well, which is exactly what we're trying to do here. We are hamstringing ourselves from being able to effectively have a debate with the House. The House knows what this bill is. They've debated this bill. It got ruled out of order on what many of us think was a bad ruling. This was a chance for them to, we were going to take out the offending language. Let them have a straight-up vote on the non-offending language, and it just seems like a reasonable thing to do. I understand the ruling of the president. He can only rule on what the rules are before him. Let me ask, how long have we seen him, how many times have we seen him take that long to rule? It must have been a close call, right?
Not this president. This president, never seen him take that long.
Well, that's what I'm saying.
Correct.
So, I mean, sort of if it takes that long, tie goes to the runner, it seems like, but in this case it didn't. And I respect his ruling. And I don't want the fact that I said I was going to appeal it to say I don't respect it, but it's the only way to get the floor right now to talk about it.
But it's also true that the ruling only happens if the point gets raised, right?
That's right.
But sometimes it's incumbent on us, isn't it, to protect the institution we serve in so we don't get hamstrung by the House and the governor in future sessions.
You're absolutely right, Senator.
Thank you.
Thank you.
Okay. Senator from Darling, for what purpose you rise?
Very briefly, see the Senator will yield.
Senator Yield?
Senator,
Wait a minute. Senator Yield?
I do.
Yeah, Senator Yield.
Senator, I know you've already said your intentions, and I think just for the benefit of the body, the senator, the president has ruled. I think that the ruling is accurate based upon what we have. But you have already indicated that you're going to end up pulling it down. But I guess you would end up taking a moment telling it is rare that we end up having an appeal to the chair of an issue that's just like this. And what you're trying to do, you're just trying to use this as a moment to sort of stake out a position once again, correct?
I am to say that if we're going to get the rulings that we've been getting, and I'm not complaining about them because those are the words in the rule book, we may want to change some of the rules in the rule book. We used to have a much more expansive definition of germaneness. And we decided, I'm not sure why, but we decided against it thinking, well, we'll just try to narrowly, but they didn't, okay? They kept the wide open germaneness rule. We take the narrow rule, and so we don't get to send them as many opportunities of what our feelings are on a bill as they get to send us of what their position is on. We have to either take their position or not. We want to send them ours. They don't have to take it up because we can't get it to them.
Here we go again, the Senate is being the Senate. What we have is that we have a president that rules on an issue that we know that is very dear to the hearts of many of us, and it weighs on his heart to end up doing it as well. But it's important to do the things that are right. And what we have seen is that we're not going to try to be legislature, executive, and judicial. We're not going to end up using the Constitution to end up ruling on issues. You and I have been involved in this before when we had someone that pulled, I think, a rape on a third time for the death penalty, which we know is totally unconstitutional, right? And so what we cannot do is continue to do that. And so I'll go ahead and get out of the way so that you can end up withdrawing, and then I'm going to move to carry over the bill.
Well, I appreciate the work of the Senate and the President and the staff in at least considering this and obviously giving it a very thoughtful consideration. And with that, I'm going to accept the ruling of the chair and ask unanimous consent to withdraw my appeal.
Senator from Orangeburg asks unanimous consent to withdraw his appeal of the chair. Is there an objection? Hearing none, the appeal is withdrawn.
Mr. President.
Senator Beaufort, for what purpose?
Unanimous consent request
State your request.
that the words of the senator from Orangeburg recorded in the journal.
Without objection. Yes, sir.
The bill.
Hold on just a minute. Hold 1 minute. Is there objection to the Senator from Orangeburg's unanimous consent request to withdraw the appeal? Hearing none, the appeal is withdrawn.